My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about California and their new requirement for companies to do cybersecurity risk assessments. So, the California overarching law, the CCPA, has regulations that were finalized in 2025 that start in 2026, and they require companies to look deeper at their cybersecurity stance and be able to assess it in a way that, if asked by a regulator or anyone, they can provide documentation to those regulators about those things. So, part of this assessment that's required, it does a couple things. So, first of all, for companies that are subject to the CCPA already, they need to pay very close attention to it. But then also, as it relates to revenue thresholds, but also this is kind of a risk based approach. So companies that are doing more sensitive data processing as it relates to cybersecurity, they need to really pay close attention to this. So there are requirements in this regulation as it relates to things like neural data, processing of data as it relates to AI, anything that California considers in the sensitive data category needs to be looked at. And actually, there are steps. So there are steps to this regulation as it's rolled out over the next couple of years, based obviously on companies that have higher revenue thresholds at first, and also higher maybe sensitive data uses that they have. But I think this particular thing is going to be very influential to see how not only California implements this, but then also how other states implement this for companies who already do risk assessments, things like ISO. They'll be familiar with some of these categories, and maybe they aren't duplicating their efforts there, but they really need to look at what California is asking of them to do, because there may be gaps there. Also, for companies that are already subject to things like GDPR in Europe and are accustomed to certain risk assessments, this regulation probably won't be a huge jump for them, because it will likely align very closely. But what we're seeing is California adopting a lot of the risk assessment type things that we see in the EU. For companies, I think it's going to be very different, because they may not have to submit their actual risk assessment to the state of California unless they're asked. And if they're asked, they have to do so within 30 days. But then they do at some point over the next couple of years, they may have to provide a certification to the state of California saying that they've done this thing. So this is a huge deal, because companies at this point, companies really didn't have to respond to regulators about their cybersecurity stance unless there was a breach. So basically, California is trying to be more proactive, trying to make sure that companies are doing these types of assessments. It really will help companies. I know it may be painful at first if companies have not been in the habit of being able to collect this type of information, but I think all in all, this will help companies become more mature in cybersecurity, understand where their gaps are, and understand what regulators will expect. So I think what California is doing is going to set a gold standard for other states and other companies. And what I've seen over the years with these regulations, I've seen companies really adopt these things and really push those requirements down to their third party. So that's what I think is going to happen. So it remains to be seen how people will take this, because this is being rolled out in phases over the next couple of years. We probably won't hear a lot about this until certain thresholds are being met or certain requirements go into effect. That's it. Thank you.